or have a CCE that detention is necessary to meet a compelling government interest. That's why the bond is set at what it is.
He would like to address some of the violations. I have not discussed any of this with.
It's probably not a good idea because number one, we live stream, so the entire world sees what's going on. Number one. Number two, anything you say here, they can use it against you to prove guilt. Number three, you've not spoken with your lawyer because what you say when you think you are trying to help may in fact hurt your case. So that's why. It's probably not a good idea, at least until you've spoken with Antonio to see whether it's a good idea to say what you want to say.
In regards to the $20,000 bond, I believe that's excessive.
I agree with you, and I'm willing to go down, Antonio. It shows that bond was made in the felony case. Do you know what happened with that? Did he make another bond? Did they give him a PR bond on that? The bond was reinstated after all that.
The $10,000 bond?
They reinstated the bond. Yeah.
Well, that's something wrong.
I don't know.
As far as what the court is going to have to decide here, the reduction, I would ask that the court take that into consideration. If the felony court has decided to reinstate it.
Mr. Johnson, I want you to understand something and I want you to hear me clear. I will do everything in my power to protect the public every single way, shape, form. I don't care who you are. I don't care what your explanation is. Jesus came down to tell you to do something. I don't care. If I find that you endanger my public, I will let loose on you and your bond. I don't care who you are, where you're going, but you better keep my county safe because if you don't, I will make your bond sky high. And I don't care what your explanation is. Do you understand?
Yes, Your Honor.
So, and I'm going to tell you now, I don't play like other judges. One violation report, it's enough for me to put you in there and make the bond so high you'll have hair falling out. Do you understand? I'll reduce your bond to $10,000 now, but you're to get a GPS monitor prior to your release. And if I find that you go anywhere near this person, I'm telling you now, I'm going to let loose. You're not to consume alcohol, illegal drugs, and I'm going to test you like crazy because I want to know that you're not using it. What do you do with yourself now in life? You work?
Yes, sir.
What do you do?
Structure.
Okay. Full-time job. When you have too much time on your hands, you become self-destructive. So within 10 days of your release, I want proof that you're actually working. And if you don't give me proof that you're working, then I'm going to put you back. Do you understand?
Sir.
You cannot believe how much I'm micromanaged, and I'm going to micromanage the hell out of this case to make sure that number one, you're working. Number two, that you're safe to my public. And I don't care if you're kicking and screaming when you throw you back. I'm giving you now the opportunity to do what you need to do. But if you don't, I only have one place for you.
Judge, would you like a curfew on the GPS or any exclusion zone?
Yeah, the exclusion zone from the complaining witness in this case, and he's not to have any contact with her. 200 feet.
Yes, sir.
Okay. Do you have any questions?
Does it affect the other GPS I had already? Is it going to be into one?
Yeah. You're only going to get one, and we'll tack on both so that if there are any violations, they'll know and we will know at the same time. It's nonsensical to put two different ones on you. We'll just have one, but we kind of share the information so we know, and I'm going to have on our checking it every couple of days to make sure that you're in compliance.
Okay, and
Because the minute you're out of compliance, I'm going to haul you back in here. And if you don't come, we just issue a warrant. And then if you thought 20,000 was bad, just wait. I have bonds now 50. I have one bond at 150. So, just be safe. That's all we ask. There are so many other fish in the sea. I don't understand how a woman could get into your skin so bad that you will want to live in a 6x9 box. Because I tell you what, if you were calm, cool, and collective, and when they try to bait you into this BS, whatever, you just turn and walk your happy butt the other way and just play it cool. Holy moly, you'll have such a different effect on these people. Just calm, cool, and collective. Don't let people spiral you out of control. I mean, you're wearing orange now. All your priors have but to do with one thing. And if you play it cool, I bet you none of that would happen. Really, that's what life's about. Play cool, get a good person, and move on. All right. Thanks. Mr. Fox, let me express my extreme disappointment. And I think what makes me so very upset is that when people truly need help, the fact that we push it along. And since day one, we've known residential has been needed.
It's time, so.
You now stand charged with another DWI. You're also charged with evading arrest in a motor vehicle. On that one, you're facing up to 10 years in prison. A minimum of 2 years, maximum of 10 years in prison. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The officers observed the defendant engage in a race with other on a road in Harris County, Texas. The officer attempted to catch up to the vehicle and was unable to catch up to the other driver. However, the officer caught up to the defendant's vehicle and attempted to initiate a traffic stop by activating lights and sirens. The defendant failed to stop and engaged officers in a 13-mile pursuit. When officers made contact, they observed the defendant step out of the driver's side of the vehicle, and the officers observed a strong odor of an alcoholic beverage, slurred speech, red glassy eyes, and unsteadiness. The defendant admitted to drinking a bottle of wine and taking a Zoloft. During search of the vehicle, the officers found an empty bottle of wine and a Sonic cup that contained a liquid smelling of alcohol.
Alcohol in the car?
Yes, Judge. And the defendant refused to undergo a sobriety test. GIC was read, and the defendant refused breath. A blood search warrant was signed and executed.
Mr. Fox, did we already have an affidavit on file that he's not supposed to drive?
Let me double check.
I am now putting this affidavit that you're not to drive. If I find that you drive, and I don't care what your reason is, if you get out, because I don't know if you're getting out, then I will have a contempt hearing and you'll be facing an additional 6 months in jail and a $500 fine every time you get into a car and drive. I am now, if you get out, ordering you to be under home confinement. I think that your bond at $15,000 on the DWI is wholly insufficient, and I'm going to raise that to $50,000. I'm also going to raise the terroristic threat, the probation that you're on now. I'm also going to raise that to $50,000 and $50,000 and 1, 2, 3. How many cases does he have in Fort Bend open? I know that he has the one DWI. What else does he have?
I hope it's just the one DWI judge. But Alex is gonna have to double check for us. And also, Judge, the complainant in the terroristic threat case did reach out to the felony prosecutor because she saw that the defendant has been arrested. She is currently has filed for divorce from the defendant, and she is requesting that he is not to be in house arrest at her house that is under her name. So I'm not sure if that's the address we have on file. She's not opposing house arrest. She was requesting that.
Okay. So, I need to get Mr. Butler here so we can deal with this case as well, though. Do you mind perhaps reaching out to him, sending an email, or I'll also call out to the office as well to see. He's always in court. Hopefully he can be here now. And then as soon as the line dies down, I'll also reach out to him as well.
There was also one last Spanish THA just in it.
Okay. So she does not want any contact with him as far as. Okay, so Mr. Fox, you're not to have contact with the complaining witness in the terroristic threat. You're not to go with where they live, work.
She just said that I'm not going to live there. I mean, we talk every day that I'm sitting.
No, I mean she doesn't want to have contact with him.
No, that's not what she said.
Judge.
And when did she call the DAs?
She emailed on November 21st. So I think that she saw that the new charges had been filed. She was just concerned. She expressed concern to the public prosecutor that if the defendant is released to his home address, that's where she's currently staying, and they are going through a divorce. I don't think she'd said anything about no contact between the two. She just requests that he's not sent,
Okay, so I won't do the no contact then. Okay. Okay, I want to have a hearing on this ASAP. I'm not waiting anymore on the stuff from, damn it, he can't do anything now. He's got these cases open anyways. Wait, what a waste. All right, Mr. Fox, if you're released, like I said, home confinement, on one ankle, you will get a GPS monitor. On your other ankle, you will get a Scram ankle monitor so we know that you're not consuming alcohol. Is that it? I guess that's it, right? No weapons. And then he'll have to, prior to release, he's going to get all those. And then you'll have to find somehow another address for him to live, James, because we need the address prior. And I don't know if he's going to bond out now.
Yes, Judge.
See,
Can I get that rehabilitation that you had offered?
not while cases are open.
Well,
You have the case also that's open in Fort Bend as well. I don't know what's going to happen in there. I'll tell you, those cases take even longer to resolve than here. And then how are you going to be able to resolve that over there when you've got this stuff over here? So at some point, you're going to have to transfer over there, resolve stuff. It's even more of a mess. So all right, I guess I'm going to have you put back now. I want to wait to see if we can get Mr. Butler here today. And then if not, we'll just roll it to tomorrow until we get him.
And Judge, I have 2 more in custody.
In this courtroom hearing, the judge reviews the defendant's request for a lower bond while warning him not to discuss the facts of his case in open court, explaining that the hearing is live streamed and that anything he says could later be used against him. The judge urges him to wait until he has spoken with his attorney before making any statements that could damage his defense. After hearing arguments from both sides, The judge agrees to reduce the defendant's bond but makes it clear that public safety comes first. He orders a GPS ankle monitor, strict exclusion zones around the alleged victim, regular drug and alcohol testing, and proof of full-time employment within days of release. The judge warns that even a single violation could result in the defendant being sent back to jail with a much higher bond. The hearing then turns to another defendant facing a new DWI charge, an alleged police pursuit, and multiple pending criminal cases. According to prosecutors, officers observed signs of intoxication. The defendant admitted drinking alcohol, and he refused both field sobriety and breath tests. Concerned by the growing number of charges, the judge dramatically increases his bond, orders home confinement, GPS monitoring, alcohol monitoring, and prohibits him from driving or possessing weapons while the case is pending. Before ending the hearing, the judge explains that rehabilitation cannot move forward while so many criminal cases remain unresolved. He emphasizes that protecting the public is the court's highest priority and warns both defendants that accountability, not excuses, will determine what happens next. The hearing closes with a powerful reminder that every decision made in court is aimed at balancing second chances with community safety.